more closely at their own death and dying process and how they want to prepare and the resources they need, and then asking from our communities, hey, let's get resourced together. It's been a journey somewhat inspired by Martha Castriata, who was a member of our community at Mountain Vista, who also worked with Final Exit Network to end her own life last year. And her story and her honesty and her invitation to us was to look at our own death and our own dying process. So this is a response and a call to Martha Castriata. And I'm going to light my chalice. And if you have a chalice at home, you might light yours too. And I'm going to light mine in honor of Martha and in honor of the kinds of conversations we start when we ask each other to have a hard conversation. And welcome, welcome. We have a very special speaker today, and our speaker is Althea Halchuk, and she comes highly acclaimed from Final Exit Network, which is a national organization that anyone attending this workshop actually has access to the resources for. We'll get some of those for you in the chat box. But Althea has a lot of wisdom and skill. She's the founder of Ending Well Patient Advocacy, and she's a board certified patient advocate who focuses specifically on end-of-life planning and counseling. And she's all about making sure that people have a good death. She earned an executive JD in health law in 2012 and has been a professional mediator for over 18 years. She's been a bedside hospice volunteer for over 16 years, and she earned a thanatology certification in 2015. She continues to prepare people who are terminally ill, and she comes alongside the bereaved and provides death education. She earned a facilitation certificate in advanced care planning from Respecting Choices, and she offers classes on advanced care planning in the community. In 2021, she became Final Exit Network Surrogate Consultant, where she counsels healthcare surrogates, medical POAs, and any hospital staff on the very thorny advanced directive and clinical ethical issues. We are very lucky to have Althea here today. She received some of your questions in advance. She's going to reflect on those.
My role with Final Exit is I help surrogates and healthcare proxies who may be having a problem enforcing an advanced directive. And I also answer member questions about their directives and their living. Final Exit Network's mission is to educate qualified individuals in practical, peaceful ways to end their lives, offer a compassionate bedside presence, and defend their right to choose. Their other mission is about educating people about their options and their choices at end of life. And my role with FEN is mostly education. In my program today, I'll review advanced directives and offer some tips on choosing an effective surrogate and provide some ways to ensure that your advanced directives are followed. The key to having your healthcare wishes honored is choosing a surrogate who will speak for you and make sure your treatment wishes are followed. Your surrogate is so critical to the success of your planning. It's the first question in every advanced directive. So who will be your surrogate? Yay, it went forward. I'm not a technical person, so this is sometimes a challenge. So listen to Ben. Preparation is everything. By failing to prepare, you are preparing to fail. Having no plan can have other people choosing critical care for you when you can't speak for yourself. Often you'll get treatment you may not have wanted, or you'll have decisions made for you by a person you would not have chosen. To quote Emily Dickinson, "Because I could not stop for death, he kindly stopped for me." We're all going to die. Yes, me included, everyone on this call. It's 100% mortality rate. We need to prepare for our ending and do it right. Advanced care planning, though, is not just for end-of-life care. A medical crisis can happen in the blink of an eye. How much worse would a car accident have been if you were in a coma in an ICU with no directive and no surrogate? My 49-year-old brother-in-law had a massive stroke, no advanced directive, no chosen surrogate. His 3 older brothers were blindly navigating through it and choosing his care, but they disagreed about what to do. Many of these events are survivable, but living a good quality of life and merely surviving can look very different. Please don't wait until you're too sick or it's too late and you're in a coma, like my brother-in-law, to choose your future healthcare treatments. Here are the poster girls for failing to prepare, and you probably heard of them. Karen Ann Quinlan, Nancy Cruzan, and Terry Schiavo were all in their 20s when they ended up in permanent vegetative states, or another word for a coma, permanent coma, and they had no hope of recovery. Karen Quinlan mixed diet, drugs, and alcohol. Nancy Cruzan was in a car accident, and Terry Schiavo had a cardiac arrest. All three were artificially kept alive for many years because none had written an advance directive. After many years of fighting, the courts ultimately gave the three families the right to discontinue life support. Although in the case of Terry Schiavo, that made national news. Everybody who was anybody got involved in it and shouldn't have. It should have been a private family matter, but it made the headlines. And her husband was ultimately allowed to take her off life support. And they're still fighting about it, her family and her husband. All three were at the center of landmark cases in the right to die movement and the fight for people to make their own medical decisions, but they weren't even aware of it. It caused so much heartache for their family and friends. It really shaped their families' lives when this happened to their daughters and wife in that case. Don't let this happen to you. Create an advance directive and have conversations about your treatment, wishes, and goals with everyone in your family. And don't forget your close friends. Every competent adult over the age of 18 can and should have an advance directive. Informed consent. In 1914, New York Supreme Court Judge Benjamin Cardozo stated, every human being of adult years and sound mind has a right to determine what shall be done with his own body. Every competent adult has a constitutionally protected right to refuse medical care. The other half of that quote, which people don't often hear, is that he said that any surgeon or medical person who performs any kind of treatment on a person without their consent, it's a crime, it's battery. So really, informed consent, this is what it's all about. In 1914, that was quite a long time ago. So informed consent, it must be voluntary, informed, of course. They must tell the patient what they're going to do and what the consequences are. And the patients must have the capacity to refuse whatever it is they're offering. The choice should be made without undue influence from others. The right to make your own healthcare choices was codified into federal law by the Patient Self-Determination Act. It was passed in 1990 and enacted in 1991. The loss and this was thanks to Nancy Cruzan, they had been kicking it around Congress for a while, but her case made headlines, and then they really got down to business and passed the law. The loss by her parents, they went to the Supreme Court to have her life support removed. It shined a light on the need for advance directives because they turned it down and kicked it back to the lower court. They said because she was incapacitated and had no advance directive, had nothing, they had to take more care than if from any other reason. So that shined a light on the need for written advance directives. The compliance of this act is mandatory on healthcare institutions. They need to communicate and protect patient rights. And advance directives give competent adult patients the right to accept or reject medical treatment and the right to choose a surrogate. When it was first enacted, the medical staff just followed the law by simply asking people if they had one. Like, you know, it didn't really help people understand what an advance directive is, but it covered them in the law. In 2016, Medicare, knowing all this, began paying doctors to have advanced planning conversations with their patient as part of their wellness visit. If the patient had an advance directive, the physician or PCP would get a copy, and it would go into, if the hospital had an electronic medical record, at least they had a copy of it. If they didn't, someone on their team would hopefully explain what an advance directive is and help patients fill one out. Part of the law requires that your surrogate make health care decisions that are in accordance with your wishes, including your religious and moral beliefs, or they make decisions that are a reflection of your values to the extent your surrogate knows what those values are and or can find out with reasonable effort, like asking your next of kin. Surrogate doesn't necessarily have to be anyone in your family. So if they can find out what you want, they need to find out. And if they don't know your wishes and can't find out about them, they make decisions that are in your best interest. And I'll talk about best interests in a minute. Once you lose capacity, you no longer have control over your decisions. So it's important for you to think about these issues ahead of time and execute a medical power of attorney or a living will. This will allow you to have the most input in your healthcare decisions after you lose capacity to make decisions for yourself. And capacity and competency are two terms people kick around a lot like they're the same thing, and they're not. They're two very different things. Each term has a distinct meaning and intent. Capacity is a clinical determination, and competency is determined by a court. My brother-in-law is declared incompetent. My other brother-in-law had to go to court to take over his healthcare and his financial dealings, and a court determined that. Capacity involves a person's ability to make informed decisions about medical care and provide informed consent. Patients with decision-making capacity must understand the consequences, risks, benefits, and alternatives to treatment. Capacity is determined at this point in time, and it needs to be reassessed with each major decision. So it can happen where a person has capacity one day, and then the next day, because they're on some kind of medication, they don't have capacity. So people can be in and out of capacity, and actually the benchmark is quite low for it. Competence is a legal term and a judicial process that determines the capability of a person to act on their own behalf or have the mental capacity to participate in legal proceedings or transactions, mostly of a financial nature. And here's the best interest considerations that your surrogate has to follow. They have to look, so how are they supposed to know all this? It requires them to consider and determine your medical condition and prognosis, the dignity and uniqueness of your personhood, whether or not it's the possibility of extending, preserving, improving, or restoring your life or your functioning, the possibility of relieving your suffering, and the balance of benefits of any proposed treatment against concerns and values that a reasonable person in your circumstance would want to consider. So it's a reasonable person standard. It's what your next door neighbor might want for themselves if they found themselves in this position. And you can tell by this, some of these are murky, subjective, and sometimes there's no straightforward answer, and the surrogate really needs to do a deep dive into what they think the person would want if they know them, and if they don't know them, like what a reasonable person would think. These are advanced care planning forms for everywhere, basically, except the one in the corner is Arizona. Arizona has a whole, it's under the Attorney General's office. It's a life care planning packet. The parts of an advance directive are the healthcare power of attorney, that's number one, or the surrogate, someone you trust to act on your behalf when you can't speak for yourself. The other part is to create a living will, a written statement of your end-of-life wishes about your healthcare, medical treatment preferences, and other choices. It isn't just about treatment options. Here you can spell out your memorial or funeral plans, such as a casket or cremation, a green burial, a burial at sea, organ donation, part, tissues, liver, whatever it is, or nothing. And many other end-of-life choices. You can pre-plan it all. The Advance Directive is a tool to help you think through and communicate your end-of-life treatment and non-treatment choices. Advance directives are state-specific, so be sure to pick the one that's approved by your state. And again, they have a free form, and Prepare is also free. A bunch of medical people got together and created this Prepare form because they didn't like the boilerplate Advanced Directive forms, which is what the Arizona form is. And if you live in 2 different states, you need to make sure that you're covered under both states. And mostly it's really about signing requirements. I find that some states require a notary, other states don't. New Mexico, you don't have to have anybody sign. So really it depends on where you live and where you're going to use this Advanced Directive. I recommend 5 wishes mostly to my clients. Final Exit doesn't have really a position on this. That, you know, this is me. This is how I feel about 5 wishes, because I find the legal forms are they're cumbersome and they're full of legalese that people don't really understand. And a lot of people have filled these out when they've had a trust done. And I did that. My husband and I did that. And, you know, we looked at this form and it like says really not much of anything. It just says what you really, if you have one, great, it's better than nothing. But 5 wishes you can use to express however you want to be treated when you're seriously ill. All you do is check a box, circle a direction, write a few sentences. The one thing about it, though, is there is a cost. And it's $5 plus shipping for one form. Online, it's $10. But if you Google 5 wishes, a few organizations offer them for free. You just provide an email and they'll send you a link so you can get it for free. In Arizona, you only need 1 witness or a notary. That's the signing requirement in Arizona. And what are the 5 wishes? Again, choosing a surrogate, medical treatment I want or don't want, how comfortable I want to be, how I want people to treat me. Do you want, you know, lavender oil rubbed on your body? Do you want nobody in the room? What I want my loved ones to know. Do you want to apologize to somebody? Do you want to tell somebody some secret that you don't want to go to your grave with? These are the kinds of things you can put in there. I have a client that used this form and she had 3 pages of typed wishes that she added 2 or 5 wishes. That's the beauty of it. It really becomes your advanced directive in the way you want to say it. Advanced care planning, the most important thing about it, I think, is the conversations you have with the people around you. You need to have candid conversations, and they're hard. They're very hard conversations to have. But you need to have them with anybody that might be contacted about your medical condition. Nancy Cruzan was finally taken off life support because she had the discussions with her work friends about her end-of-life wishes. After the Supreme Court denied her parents, the lower court accepted the testimony from her friends and allowed her to die. She said, you know, they were on a break or something, and she said, you know, I never want to be hooked up like a vegetable like that, you know, just let me die. So she says this to her friends. They testified, this is what she said to us. This is like her worst nightmare, what is happening to her now. So they allowed her parents to take her off life support. This is how important the conversations are, that somebody that you work with can come forward and say, you know what, we need to stop this right now. You only die once, so think of the advanced directive as your roadmap and the conversations as your surrogate as the directions on the map. People may assume others are on the same wavelength when it comes to treatments, or they understand your goals and wishes, but it's all about expectations. Spell out your needs and how you expect your surrogate to answer and carry out those needs. You're trusting this person with your life. Is there any wiggle room for the surrogate to make decisions that are beyond those listed in your advance directive? They should have enough flexibility to address unforeseeable or subjective issues as long as it's in your best interest, which we've talked about. What does quality of life mean for you? And at what point will you consider withdrawing nutrition or hydration, if ever? Will your surrogate be able to move you into a care facility, a hospice, or provide only comfort care? All of this requires several conversations with your surrogate. So what is a surrogate? I keep saying that word. And who do you choose? They're really just a substitute healthcare decision maker. This person speaks for the patient who lacks decisional capacity. Again, we talked about capacity. They implement your advance directive and consent to or refuse some or all medical treatments. You need to carefully choose a person who will make decisions in accordance with your wishes and end-of-life goals. The best surrogate may not be your spouse, your child, or even your best friend. Your appointed decision maker may also go by different names: a healthcare agent, a proxy, a durable medical power of attorney, or any other authorized decision maker. Regardless of the terminology, it's the individual who is recognized to make decisions on behalf of an incapacitated patient. What are the traits to look for when choosing an effective surrogate if it isn't going to be your husband of 50 years? These are the kinds of things, if you want your advance directive to be followed, and maybe if your husband or wife would do all those things, but here's some traits that you should look for. You want a person who's comfortable making decisions on your behalf, even if your wishes differ from their own. This is about you and not about your surrogate. You need someone with the emotional strength to carry out choices at end of life. Some people might feel guilty or second guess themselves as your surrogate. Can they put those feelings aside in order to do what's best for you? You need to find out. Someone who will stand up for your wishes and won't be intimidated, bullied, or guilted into something. They won't cave to pressure or back down when a medical request goes against your wishes, but will challenge treatment options contrary to yours. You want a person who isn't afraid to ask questions or ask for help. A surrogate isn't expected to know everything, and it can be kind of intimidating when you're with a group of professional doctors and medical people and they're, spouting all these terms that you have no idea what they are, but you can ask. You're the person in charge in that situation. You should seek help from others if you feel ignored, overwhelmed, outnumbered, and it can come from a hospital ethics committee, a legal or compliance department, or me. If you're a FEN member, you can call me up and I'll walk you through your options. I'll even arrange to have a meeting with whatever person is trying to push you into something you don't think is right. Most important, you want a person who agrees to be your surrogate and is ready, willing, and able to serve at a moment's notice. A person who understands your wishes and will enforce them. How do you ask someone to be a surrogate? It's really a big responsibility if you've ever been one. I just had an aunt die and I was her surrogate 2,500 miles away, but I visited where she lived pretty often. So I definitely saw her a lot, but still, really, it is a big responsibility. It's like being an executor in an estate. If you've ever done that, then you know what I mean. Pick a quiet place and tell them you have a favor that you'll hope they'll never need to do. Explain what you're asking them, but by telling them what a healthcare agent does. Find out if they thought about their own healthcare decisions at the end of life. Do they have an advance directive? Have they chosen a surrogate? Explain how you want the decisions to be made and what you expect. What happens if I don't choose? When you have to make a choice and don't make it, that in and of itself is a choice, isn't it though? I mean, at one point or another, things happen. So if you don't choose, the choice will definitely be made for you. They have to get decisions made. So they're going to make the choice. It may be somebody you'd never want, like your least favorite sibling, or your eldest child who's irresponsible or worse. This reminds me of my brother-in-laws, actually. One is saying, let's keep them on life support, The other saying, I say we shouldn't let him linger. And really, there's old man Winter in the bed. You know, he didn't pick a surrogate, so now somebody's choosing and they can't agree on the choice. I just had this happen. A father had COVID and he was in a coma in ICU for 2 weeks. His siblings wanted to keep him alive. They kept saying, do everything, do everything. And his daughter, who was in her 20s, said, no, I talked to my father. He doesn't want this. He never wanted this. He's not going to come out of this. They've told us that. He's really, I think we should take him off life support and let nature take its course. And so she did that. She had the power to do it. Even though he hadn't named her as his surrogate, she was the one in line that had the power. So the most conflict that medical people see is in an ICU, in this situation right here. Another common scenario is a faraway relative who hasn't seen the patient in years, and they swoop in, and that's kind of the word they use, to tell everyone what they think should be done. This is from the New Yorker, and I love this. I forgot to get her kugel recipe. You know, that's the regret, but I'm sure there's more lofty regrets than that. Although my mother was a great pie baker, and she made lemon meringue pie where the little droplets came off the meringue. It was a work of art, really, and I never got her recipe. So that's one of my regrets. I didn't have my mother teach me how to make her lemon meringue pie. Make sure you don't have any regrets, and get that kugel recipe or lemon meringue pie. If you don't make a decision, here's the hierarchy in Arizona. In Arizona is by law. In most other states, it's pretty typical. This is the hierarchy. But there's some states that have no system at all. I just did a presentation in California, and their system is kind of haphazard, I'd call it, at best. And really it's the attending who kind of figures out who the best person might be. And then there's a list of people, same as this, but really choosing your own is ideal. So here's the first, first is a guardian that the court may appoint, your spouse, adult children, and the order is the oldest first, parents, your domestic partner, siblings, and adult close friends. And we saw how important adult close friends can be. And sometimes they're the ones that you know you best. And so think about that when you're choosing a surrogate. And what happens if your surrogate is away on vacation, backpacking through Africa, or away on business, no longer willing to act as your agent? They're deceased, otherwise unavailable in a crisis. You need to plan ahead and pick an alternate. And I sent Reverend Sam a PDF. I just wrote a blog on why two heads are not better than one. You want to pick one person. You don't want co-surrogates, because first of all, even if these people love each other and want what's best for the patient, they may disagree on what's best. And so you don't want conflict. And you don't want the medical people to have to contact two people in an emergency, because if they're both named, they're going to try to reach both people. So you want one person, otherwise it could get messy and you may not get the care you want. Here are some things to consider about advanced directives. They're not all that complicated, but you're stating wishes based on a hypothetical situation. Patient and people's wishes can change. What you wanted when you were 35 may not be what you want when you're 75. And circumstances can change, or like a diagnosis. You can revoke your surrogate and appoint a new one at any time. You don't always have to have the same person. Wishes may change due to remarriage, health, relocation, a new cure. Consider using a lawyer if your advanced directive is complicated, although you don't need an attorney to create an advanced directive. You can revoke it orally by telling your healthcare provider you don't want one part or the whole thing. enforced, but you can't have any cross outs. You can't cross out Jack Jones and write in Mary Smith. You have to do a whole new advance directive. And when you do that, it's like redoing it. They go by the last date. Copies are fine. You can have a copy, but you need to collect your copies that you gave to various people and give them the new directive. Another thing that you should do is you should consider making a video as a backup. There's nothing like hearing it from the horse's mouth, especially when you need to prove to somebody who swooped in from out of town that mom really didn't want a feeding tube. And it can be reassuring for the surrogate and the family to hear it in mom or dad or sister, whoever, their voice. They're saying, this is what I want. This is what I don't want. You can video it on your smartphone, on your computer. You can put it on a thumb drive, and it's really just a backup for your advance directive to help your surrogate get your advance directive honored. Excuse me. When should you review your advance directive? They call this the 6 Ds. You actually should review it every year, such as on your birthday or healthcare decisions day, which is always on April 6th, but COVID kind of messed that up. But I think we're back again this year to April 16th, the day after taxes, is healthcare decisions day. But here are the 6 Ds of when it's a good idea to do it anyway. Every decade, minimum of 10 years. Probably too long if you're in your 70s plus, but it's fine when you're 35 years old and you have a family. You probably would want the same thing if you were 40 years old or 45 years, 50 years old. You have a decline in your health. Are you having more health issues than you had before? Are you on that trajectory? Maybe you want to take a look and see what your health, how your health would affect your advance directive right now. Your diagnosis changes. You seem healthy one day and get a cancer diagnosis the next. Suddenly your future scenario is here. I heard of 2 people in the last 2 weeks that have stage 4 liver cancer. And these people were healthy. They had no idea. They started to have some issues and they were tested, and there you go. So what does your advance directive look like now that you have that happening? Divorce. In most states, once your divorce is final, your ex cannot be your surrogate. So keep that in mind. I think there are some states, though, that will allow it, but you have to specifically say it, and I'm not sure which states, but it can be done. Distance of your surrogate. Like I said, I was my aunt's surrogate. 2 aunts, 2 elderly, they were in their 90s. They both live in Massachusetts. I'm in Arizona, but I took care of them from a distance. So distance may not be a thing unless you're not comfortable with somebody making healthcare decisions from you from afar. But COVID really opened up the door for telemedicine, and you can be right inside that ICU on a tablet, and they can be talking to you. So really, distance, I don't think is such a big factor. The death of your surrogate or another loved one would probably be a good time to take a look, especially if it's your surrogate, for you to review and make any changes. Why do so many advance directives fail? And they do fail often. The copy of your advance directive was not provided to your family or your doctor. The AARP says 35% of advance directives can't even be found. So you did it, but where is it? Keep it handy. Give a copy to anyone who might be called upon to affect your health care, and keep one in your glove box in case you're in an accident. I said this at it was a live presentation, and there was an EMT in the audience, and she raised her hand and she said, you know, that might work, she said, but not really with EMT. She said, because first of all, we'd have to figure out what you want, and we don't have time for that. The best thing is to keep an emergency contact on your smartphone, which is really located in a place before you have to put in the PIN numbers. And I just did this. I have an Android, and I put my surrogate and co-surrogate. So if they turned on my phone, they do the sweep up motion, and that's where you would put the pin. But right below it says emergency call, and you press that button and 2 people come up, and either one of them would be fine in my book, making medical decisions for me. So that the EMT said is far better to do that, or keep a wallet card with your surrogate's name and contact number in your purse or in your wallet. You can upload your advanced directives to My Directives, or there's an app, Mind Your Loved Ones. But if you're in an accident, nobody's going to do that. They may do it at the hospital, but who knows? Others are unaware your advanced directive was even completed or where it is. No one knew about it, and people get queasy talking about death-related topics. Let your family know where it is, but under no circumstances put it in a safe deposit box. Because by the time they get into that box, if you are incapacitated, it'll be too late. Reason number 3, they fail. The surrogate is unaware they were chosen. There's a great podcast, if you haven't heard it, called The Heart of Hospice, and Helen Bauer is one of the co-hosts. And she told me that she had a surprise surrogacy. She got a call from an ICU asking what they should do for an incapacitated patient who had named Helen as the surrogate. And Helen was a hospice nurse. I mean, of all people to be the surrogate, she's probably a very good choice, but she really didn't know this woman. She was some kind of far-flung family person that she really didn't have much contact with. And so she really had a hard time with this. She said she lost sleep and she felt guilt and she had anxiety over it. And here she is in the death business, end of life business, knowing what works and what doesn't. And she said it was a real struggle. So make sure your surrogate knows and agrees to be your surrogate. The surrogate is unavailable when needed. Who knows? They're climbing a mountain somewhere and there's no cell reception. So that's why you want an alternate. If the surrogate is not qualified, the medical staff won't follow your directive, and that happens. The surrogate refuses to follow the directions. While it might have seemed like a good idea at the time to be mom's surrogate, having to turn a ventilator off can be emotionally problematic for many. Family members disagree on what's best. Again, the biggest source of conflict in an ICU at end of life is family disagreements. My sister and I, we can't agree on where to go for dinner. So I can imagine us at somebody's deathbed and she thinks one thing and I think another. I love my sister and that wouldn't happen, but you know what I mean. And if you remember the swooper, if you have an advanced directive and a named surrogate, only that person has the right to follow your wishes. Another reason they fail is the surrogate understanding of the options differs from what the patient really meant. So avoid vague, subjective, or boilerplate terms such as extraordinary efforts or heroic measures. Pacemakers used to be extraordinary, but now they're routine. However, they and other medical devices are difficult to turn off. You're legally allowed to turn them off, but tell that to some doctor in a hospital who really, they don't want to turn it off. Katie Butler, she's a end of life speaker. She's written several books. One was Knocking on Heaven's Door, and her father had a pacemaker, and her and her mother went through hell trying to get that thing turned off, and he suffered and he had dementia. Read that book and go to her website. She has a lot of great articles on end of life topics and this whole thing around pacemakers. If you become incapacitated, would you want a pacemaker? I read a story today about an 86-year-old woman who had valve surgery. She was already moderately demented, and they did valve surgery, which kept her alive for another 8 years. So really, is that a good thing? No, I think not. She was miserable, according to her son. So would you want a pacemaker? Or antibiotics? Antibiotics are one of the most, Bill Clinton just had, he developed sepsis because he had a urinary tract infection. And he collapsed. They bring him to the hospital, they find out, they give him antibiotics, cured. But if you're at end of life and you really want to die, you've had enough, quality of life is not there, you can say no to antibiotics. But it's one of the things that is kind of the standard of care when you get dragged into an emergency room and they do a test. Bill Clinton would have been dead in 3 days, and he would have gone into a coma and his organs would have shut down. So that's a legitimate, legal, peaceful way to die. But people really don't talk about it a lot. A lot of advanced directives don't mention it. So I wrote that in on mine. Would you like resuscitation at age 80 or 90? Odds are it's not going to work. You won't survive, or if you do, you'll have broken bones as a result. So you need to think about, it's not like it is on TV. Do you want CPR or not? Under what circumstances would you want a feeding tube, if ever? Once they go in, like pacemakers, it's not easy to have them removed. Spell out your treatment and non-treatment wishes in clear language. Quality of life is another one of those terms. What does it mean to you, and at what point will you find it unacceptable? Is it when you don't recognize family or friends? Is it when you can't toilet yourself? When you have to go to a nursing home? The line in the sand is different for everyone, and it can change over time. Make sure you both know where that line is and spell it out. And you can change your mind. If people do it all the time. You know, they think one thing when they set up an advance directive, and then when push comes to shove, it's like, well, maybe I really want to draw another line in the sand. Finally, no hope of recovery is so vague, it leaves the door open to a doctor or surrogate's interpretation. Some will say there's always hope, miracles can happen. How about another round of this new chemo? Then feel free to provide additional unwanted, even futile treatment. The one person I heard about the liver cancer is a relative of mine through marriage. And she also has cancer in her both lungs and her liver and her bones. It's metastasized to her bones. They meet with the oncologist, and the oncologist has told them that they have this chemo that's going to help with her liver. And my sister, who I mentioned, is a pharmaceutical rep for AstraZeneca, actually sells these drugs. She knows what they do and what they don't do. And basically, they're going to give her an infusion to try to, target the cancer in the liver, but it's already metastasized to her bones. And so really, is this futile treatment? Is this something she wants? Is this her family pushing her into it to give her another, who knows how long? Is it another few weeks or months? We don't know. So you need to say what no hope of recovery looks like for you. And when it's time to say, shut it down, I'd like to go into hospice, please. I don't know if somebody would say that, but really hospice is so underutilized and people go into it kind of too late. Most people go on like 2 weeks before they die when they could be on for 6 months or more. Medical providers can refuse to honor your treatment wishes if they have a conscientious objection, because a decision is a direct violation of their religious or ethical beliefs, or they consider your wishes medically inappropriate, or so it's outside their scope, or it's outside their scope of practice. And they can refuse if the directive goes against their facility's policy, such as in a Catholic hospital. But in both these cases, they need to tell you that they will not treat you, and they have to help you find an alternative place that will. They have an obligation to do that. That sounds easier than it is to do, but it's their obligation to do it. What's a strategy to use when facing conflict or pushback from the medical staff? They're legal documents, and doctors have a duty to respect your wishes and listen to your surrogate's directions. If a healthcare provider acts against your directive, they can be found guilty both criminally and civilly and required to pay damages. Recently, there's been many wrongful life and other types of lawsuits where a provider or a facility ignored the surrogate's orders or went against an advance directive. In some cases, the staff kept the patient alive, prolonging their death and leaving the patient and family to suffer emotional and financial injury as a result. And many have filed lawsuits. The defense used to be, how is it wrong to keep someone alive? Really, that's what we did. We kept them alive. But courts are now ruling keeping someone alive by going against their advance directive or surrogate's order is a compensable injury. You can collect money for it. In Georgia, this woman I think she was one of, if not the first ones, she filed a lawsuit. The hospital, she had a DNR for her grandmother. And they gave her CPR and kept her alive and ignored both the surrogate and the the advance directive of the patient. The Supreme Court in Georgia, their justices said it's the will of the patient or the designated agent and not the will of the healthcare provider that controls. So they can't just say, no, we think we know more than you do. So maybe the best strategy when a staff member will not listen to you as the legal surrogate is to say, you're doing this treatment without my consent, and I want my lack of consent put into the patient's medical record. It's important to leave a paper trail. They hate paper trails because it puts them on the hook for doing something they should never have done in the first place. Insist their denial to follow your directions is put into the medical record. Carry your healthcare power of attorney and your patient's advance directive with you. Don't rely on the hospital to provide it. Really, you need to be an advocate for your patient because they're incapacitated. They can't do it. Today's takeaways: create an advance directive. That's number one. Using whatever form is best and easiest for you. Just get it on paper. Video your wishes. Have the conversation about your medical end-of-life wishes with your healthcare power of attorney, your surrogate, your family and healthcare providers, and have it often. Always update your surrogate contact information and keep their number in your emergency contacts in your smartphone. Advanced directives are not one and done. Review and update them regularly and make any changes as you age, circumstances change, or as your health declines. Keep it updated and easily accessible to ensure your wishes are honored. Say you were at this presentation on March 3rd, and they will send you 4 complimentary magazines throughout the year so that you can decide. Here is my emergency, well, here's my contact, not my emergency contact, where you can reach me, call me. You can connect with FEN on their website, which is a great website, lots of good resources there. They also have an addendum for dementia, which is worth looking at if you have been diagnosed, but you still have capacity, or if you have a loved one that way, or if you just want to look at it in case it happens and add it to your advance directive. We're on LinkedIn. Good Death Society blog is wonderful. A lot of good information and different topics. The Facebook group. I sent these resources to Reverend Sam, and I think there's a couple of other ones I sent too. I always send more than people need, but it's better to have too much or not enough. Just the disclaimer is none of this can be copied. It's copyrighted by Final Exit. Any questions or comments? And I'm going to stop. I just put my email for my business email address, and it's Ending Well Patient Advocacy. And you can, if you go on my website, I write a blog, and I have a contract with Final Exit, but I also have an end-of-life consulting business. So I have a lot of good resources on there too. So that's my email address if you want to contact me that way.
I saw a couple hands. Bill, I saw you, and then Louise, I think.
The courts determine competency, but who determines capacity?
It's usually, it can be, it's usually medical people. And I've done some ethics training, and sometimes it can be the attending. It could be a neurologist who comes in. Sometimes it could be a person on the ethics committee who has medical training that can say, they ask a series of questions. And if the person answers them, you know, not like who's president, but, you know, this is the treatment we're talking about, and these are the risks and the benefits, and do you understand what we're saying, and, you know, that kind of thing. So those are the medical questions that they ask. And again, it's, you could be having capacity one day and the next day gone for whatever reason, and back the following day. So it really comes in, it can come and go.
Thanks, Bill. Is there another question out there?
I wonder if there's any reactions too, even just, it's okay if it's not a question, it can be the form of a reaction. Yeah. Or
That's
where it's
okay.
landing on you.
Talking about somebody's potential death is never a good thing. And I try to help where I can. I try to educate where I can. And even my family that's going through this, you know, like you don't want to push. Oh, you have the resource, you know, they're talking about hospice, but they don't have a clue what hospice will allow or not allow, or what the family has to do if you call hospice. I mean, hospice will come, but really you need somebody in the house, if that's what the person is, that's going to do the heavy lifting, the caregiving. You know, hospice comes and they send a nurse once a week. So.
I think Hobie wants to talk.
Yeah. Is it okay? What I'd like to ask is about 5 wishes. As I understand it, it's not a legal document. So my question is, how effective is it in getting people to follow your wishes?
It most certainly is a legal document. I don't know what's happening to me.
Oh, I think Hobie, there's some feedback on yours. So would you mute Hobie?
Sure.
Oh, okay. It's legal in the United States in all jurisdictions. The only caveat to that is if you use 5 wishes and you go on their website, they have a link that pulls up every state. And some states require you to have a notary, or require you to have 2 witnesses and a notary. And that's really the only thing that makes it, you know, it's not that it's not, it would be not legal if you don't follow your own state's signing requirements. But I had a person, I forget, I think it was in Montana. She wrote and she said, is it legal in my state? So I look up Montana or wherever it was. And they actually had a separate living will form that you had to put with your 5 wishes form. So it is legal, but you have to do a little bit of homework to make it legal, if that makes sense. It's used really, I think, probably more than any other advance directive. It's very popular. I have one. I just redid mine. I just, like this past week, I just redid it. So I trust it. Of course, I had a lot of notes on it too. Don't do this, do that, don't do this. So, and that's the beauty of it. You can make it your own.
Hobie, I just forced muted you. If you're talking again, I'm sorry. If you want to unmute. Oh yeah, Hobie's feedback happened again, and so I used my executive power and took over his wishes, and I muted him. Mary Dupuy, did you have a?
Yes, I did. I really appreciated hearing that your surrogate can be long distance, because I I actually had two people who fully understand what I want, and they are very long distance. So that was good to hear. And speaking of 5 wishes, I sent for 5 copies with the little discussion book that goes with it. And they sent me 5 wishes in Spanish. So if anyone, I've now got it in English, but if anyone knows how those 5 wishes in Spanish can be used, I will certainly donate them. That's it.
Well, that's wonderful. They usually, I order it from them a lot, and they're usually pretty good about stuff. So I don't know. I suspect there would be maybe a senior center in a Spanish community or Hispanic community that might want, put them to good use, because they're worth $5 a piece. I
Yeah,
mean,
they are.
unless you buy them in bulk. Like I do.
I'd be happy to drive them if somebody can provide me with an address. So
I don't know, Reverend Sam, you seem like you are tapped into the Tucson community.
Taft is strong, but I think, Mary, you could bring them to Mountain Vista, and I think we could I think we would find a way to put them to good use for sure.
will do.
And Hobie, I have a sample 5 wishes that I sent just so that you can look at it without having to buy it, and just take a look at it. And if you're not comfortable with that, use the one from the state. I downloaded the packet. I think it's 29 pages long because they have a lot of instructions with it. So really, whichever one you use, it's a good thing.
Yeah, I was mistaken about whether it was legal or not. And I'm glad you clarified that, because I do have it and I will use it.
Good, great.
Just seem less technical than the other things that you talked about.
I
Thanks
think
for your help.
if you read like how this form got developed, it's been around for a while. They worked with the American Bar Association to develop it. The owner of this company, this business, worked with Mother Teresa. So he's a great guy, and they aimed it at a 5th grade education. They made it simple for a reason. They want people to not have this complicated medical lingo in there that a lot of these forms have. So they made it simple on purpose.
What happens if you spend part of your time outside of the country? Like, for example, Canada, if you spend 3 to 6 months a year in Canada or someplace else?
That's a very good question. I don't know the advanced directive rules in Canada, but since you asked that question, I'll definitely find out. I think what happens in reality is if you're, say, in Canada with your advanced directive from Arizona, and you're brought to an ER and you have your directive and you're incapacitated, somehow it's available, they're going to follow it. Then, I mean, that happens in this country. If you come from Montana and come here in the wintertime, if you didn't sign it right from Montana, or if it says, signed in Maricopa County or whatever, the medical staff just wants to have a decision. That's all they want. And they want to have a decision that's in your best interest. So if you have an advanced directive, even if you have a surrogate available or not, that's what they're going to look at. That's really the important thing. So again, I don't know what the rules are in Canada. I'm sure they're very similar as far as advanced directives, but that's a great question, and I'm going to find out. I will email Reverend Sam when I get an answer to that.
Bob, go ahead.
Is there any significant difference between the healthcare power of attorney and the surrogate? I mean, is a surrogate simply the person who's named on the healthcare power of attorney?
I had a discussion with a colleague about this, and I believe there is a difference, a big difference. And one of the differences is that in some states, they allow the healthcare power of attorney to make certain decisions that they don't allow a surrogate named in the advance directive. And what those are, I can't really say, but for the most part, they have the same power. And I have people, if I'm somebody's surrogate, I have them do a healthcare power of attorney just to cover all our bases. And they sometimes are used interchangeably, and that's okay. Again, staff really just wants an answer from a surrogate, whether it's a healthcare power of attorney or not. But healthcare power of attorneys carry more weight. That's the legal thing. But again, in reality, it can be different. So it's just a matter of having, I'd say if you have a healthcare power of attorney, that's best. But for the most part, the surrogate named in an advance directive really is just as good.
Thank you.
Oh, and by the way, that debate with my colleague, she thinks that they're exactly the same. And I did some research, and they're not exactly the same, but they really do carry most of the same powers. So.
Okay.
If it's two different people,
Oh, well.
Well, then you got a problem.
Yes, and that is an issue. And so I think I also gave a PDF on a blog I wrote on advanced directives, and I think I talked about that in there. Yes, that's very important, because really it's the healthcare power of attorney that's going to carry the day. And, like, you need a lawyer to figure out, I have a law degree, but I'm not a lawyer. If you name the power of attorney prior to naming a surrogate, which one has the right, because they go by the date, and if it's the last date, but I say it's the healthcare power of attorney, but never name two different people, because that's just a recipe for disaster. Like, now you have two people that are making, again, that's why you don't have co-surrogates, because it gets too messy and cumbersome, and they have to reach both people, and who makes the ultimate decision, and what if they don't agree? Oh, I mean, mediator for 18 years, I've kind of seen a lot about conflict. So that is a recipe for disaster. So you should name the same person. And it can happen, because if you're in a law office and you're doing your trust, and the lawyer says, here, do this healthcare power of attorney, and you name, say, your husband or wife, because they're there. But then you do 5 wishes and you think, well, my daughter's a nurse, maybe she'd be the best person to choose, and you name that person. So it can easily be done if you're not aware of it. So, don't name 2 different people. That's my best advice.
Yep. And on the mental health care power of attorney, do you find that most clients in Arizona do not complete the mental health care power of attorney, which is a part of the state statute?
Sometimes, it just depends on the advance directive and how it's written. The HIPAA form has that on it, the mental health records and all of that, but I don't fill it out. I mean, I don't know.
Yeah, in the state statute.
That.
Yeah, in the state statute, it's optional. You don't have to complete it, but it's there. My wife and I both completed it. And it's pretty far reaching. And I have found in my work, when people find out what it really is, they'll say, no, thank you very much. We'll pass on that one. And it is optional, but it's pretty heavy duty.
Does it cover dementia?
I gave my wife the power to have me hospitalized against my will, basically.
Ooh,
Yeah.
Okay. Yeah. Well.
And if I have dementia
Yeah.
and nothing wrong with me, you're the problem. She has the legal right to have me committed.
See, that's one of those healthcare power of attorney things that may allow the POA to do it, but not just the surrogate. So I don't know. It seems a little drastic to me, but
See, the healthcare power of attorney is a part of the state statute in Arizona, and the living will is another part
yeah.
of it. But it's and the mental health care power of attorney, and there's other levels to the state statute besides those three.
I don't think you can have too much information or too many forms to cover yourself.
Mhm.
We're meeting a trust lawyer like in a couple of weeks, and so I'll be asking him about that. So because he likes the state form, of course, he's a lawyer. But I'm bringing my 5 wishes in, so
That's my
I'll ask him
question.
about that. Sorry.
That's my question is, do you have a good sense of at what point people should seek legal assistance for these documents? Like, is there like certain conditions or certain instances where having an attorney is better than filling out 5 wishes? Or
I suppose if it's really a complicated advanced directive, and I think maybe if someone has been diagnosed with dementia, Alzheimer's, and you are doing the supplemental form, that it might be a good idea to have a lawyer look it over to make sure you've covered all your bases that way, because the supplemental form for dementia is really VSED. It's voluntarily stopping eating and drinking, and it allows your surrogate to have you do VSED if you reach a certain point in your dementia where you've agreed ahead of time while you still had capacity. Like, it's when, if I don't recognize my grandkids, that's it. You know, I'll do VSED, but it's your surrogate that has to put it in place. And so in that case, I definitely talk to a lawyer. I had a FEN client her and her husband actually did this. They went to a lawyer, and then he got dementia, and they were covered because they had, dotted all the I's, crossed all the T's. She still had an issue though, which is why she called me, but that was more with the doctor than anything else. So I don't know, you don't need it, but if you feel more comfortable, it's, what's it going to cost to have you sit in front of a lawyer and have them talk? The thing about the dementia, the directive, is that there's no legal, the only place that allows it is Las Vegas. They passed a law that allows nursing homes to allow this, but they're the only state. So there's no settled law on it. And when there's no settled law, a nursing home could come along and say, no, we're not going to allow that. So now do you move your person out so that you can let them do VSED? Dementia is a big, there's so many things about it. It's getting worse and worse as people age. And so I think, and that's probably the only time I would suggest that. Or if you were disabled for some reason, or you had a disease that, like an autoimmune disease or MS or ALS, and you were just diagnosed, maybe that's a good time to see a lawyer and write your advance directive and try to get your wishes down so that people will follow them. That's, doctors don't have to do, like I said, they can, conscientious objection is kind of broad. So well, isn't this fun talking about all these end of life topics? But good for you for having it.
Yep.
It's one person at a time. That's it.
Well, I think we'll wrap up. I think folks have your email address, and then Jamili has the resources available. Althea, thank you for taking us
You're welcome.
one step further, and also creating a really specific resource for congregations. We're so thank you.
Great. Well, thank you for having me.
Is my internet very bad?
It's saying that, yeah.
All right. I'm sorry. Jamili,
All right.